morning. My name is Michael Lawrence. I'm a director and co-founder of INSITE. And I have with me this morning Sarah Malik. She's the founder of SOL International, a boutique law firm. Can we start perhaps with an introduction of what your firm is and what your firm's doing?
Thank you, Michael. SOL International is a boutique dispute resolution firm set up at the ADGM. We deal with all kinds of litigation and arbitration internationally, litigation in the ADGM and DIFC courts. We also deal with private client work, we deal with contractual disputes, we deal with commercial issues, setups, and latterly we've got into sports, entertainment and fashion law. So I have a background also in employment law. I practiced employment law for a number of years in the UK and both out here in the UAE. I co-wrote the first comparative guide to DFC and UAE employment law, which was published in June 2021, and then the new law comes in. So the second edition will be coming out by this summer. In terms of arbitration, internationally, I sit and speak. I'm a member of the Lagos International Panel of Arbitration Neutrals, one of 20 who's appointed worldwide. I'm appointed on the Singapore International Arbitration Middle East Users Council. I provide training worldwide, both in equality, inclusion, diversity and inclusion in arbitration. I've done that recently in Lagos, in Kazakhstan, in Malaysia. I also published a guide to GCC arbitration last year, and continue to kind of be involved in both employment and arbitration and teach both of those at master's level at Middlesex University in Dubai.
Wow.
So a bit of background. I'm also a regular person and mummy to two little children.
Busy. Thank you for giving up your time for being with us here, because it must be difficult to squeeze all that in. What we're here to do today is talk about the UAE labour law, specifically changes which have come about recently, which are going to be implemented, I believe, from February of this year.
Correct.
So I wonder if we could start, first of all, by covering what are the major changes to the labour law which have come out.
Sure. Well, firstly, it's a very exciting time in the labour law. It's the first fundamental changes since 1980, which is when the federal labour law was first introduced. And as you'll appreciate, the landscape of the UAE, where we were in 1980 and where we are today, is hugely different. And this labour law shouldn't be looked at in isolation. It's part of a huge raft of changes that have been introduced. We've had the largest number of legal reform in recent history, about 40 new laws that are coming in. Wow. The labour law has had a wholesale restructure, and probably the biggest changes, or most fundamental changes, firstly to do with contract types. Under the new regime, indefinite term contracts no longer exist. Right. The maximum is a 3-year limited contract, renewable every kind of 3 years. And
is that the default position?
That's the only position.
All
so
right, okay.
Indefinite contracts will no longer be recognised under the new law. There's been a change, and this may well have been pandemic related, and I think there's been a global change generally in attitudes towards work patterns. That's reflected in the labour law, where different work patterns are now recognised: temporary work, flexible work, part-time work. It's more akin to a more modern setup. So before we always had the one employer-employee sponsorship. It's a much more modern approach. So these new flexible working patterns are defined and recognised. Discrimination's been introduced for the first time directly into the labour law. It wasn't before. So discrimination in terms of race, colour, sex, origin, nationality, disability is all outlawed. So those are there's obviously changes also to bereavement leave has been introduced. It wasn't. Study leave has been introduced. Harassment has now been recognised. So it's been a modernising of the employment landscape, if you like. Certain provisions have been recognised that ought probably to have been recognised previously, never were. Concepts such as redundancy, the closure of workplaces. Because we always had those situations, but they were never part of the law. So as employment lawyers, we're very excited. I think it's a kind of wait and see of how this will all pan out in the courts and what will happen if there's any challenges. But
and specifically, I mean, one of the things in construction is it's being project based, and I understand there's some allowance for that type of arrangement now.
correct. You can have temporary work patterns now where you can bring somebody on board simply for that project, and that's recognised. You can also outsource and use other people's employees. There's provision within the labour law to allow that, and I think that's very kind of pertinent to the construction industry.
Yeah, particularly with subcontractors.
Absolutely.
Sometimes, and sometimes, you know, perhaps subcontractor working through a main contractor's
Correct.
setup. Yeah.
And again, I say it's part of the general, I think, intention to ensure the work patterns become easier. The UAE's opened itself up internationally to allow people to come in and work remotely, and part of that means to kind of modernise the approach and leave behind the kind of old days of it's just, as I say, the one employer, one employee, and everything's very rigid. So.
Yeah, okay. And is there anything specifically relating to gratuity, pensions and anything? Is that regime changing at all?
In terms of the gratuity is still payable now, even if you're dismissed, if you like, for cause, whereas before it was foregone. It's the same metric that's applied. It's the 21 days for each year that's worked. So there's not huge changes in terms of the gratuity.
Yeah, okay. And in construction, what are the major things which you found in terms of sanctions and changes in terms of before this law came in? Where were the main pinch points in construction?
So look, in construction, we all know that the issues that usually arise are non-payment on time, the treatment of workers, even though they don't kind of have, well, they do have remedies, but they don't bring those issues to the forefront. The control by the employer, because there's always a kind of, in terms of the industry, the one party has a, if I put this politically correctly, it has much more power, equality. There's no kind of equality of bargaining power between the parties. The new law has introduced concepts which protect the employee a lot more. It's also recognised there are issues, not only within the construction industry, but generally. So, for example, as I alluded to earlier, redundancy is recognised as a concept now.
Right, okay.
I think that's hugely important in the construction industry.
Yeah.
We all know one project can wipe out a business, cash flow can be an issue. There's regulation now of overtime hours as well, which will come on, I think, to discuss later. There's an ability for class actions to be brought now under the which is interesting whether they actually will be
unions.
Well, I was just saying that. I was saying to a colleague, are we going to end up with unions on Sheikh Zayed? I don't think we're quite there yet, but maybe that's what we're working towards. I don't know. And also concepts such as harassment that have been introduced and psychological harassment. I think these are all very pertinent issues in any industry, but particularly so in the construction industry. There's a more of a regulated playing field. And I think the awareness, once employees become aware, and right now not everybody knows there's a new law. They don't really know what's going on with the new law. But it'll be interesting in terms of those issues that we've always had in the construction industry, especially to do with wages not being paid, employers facing difficult financial times. Yeah, I think that will slowly ease because of the regulation now under the new law.
The group action is interesting. I mean, under the old law, it did sometimes happen by default when companies went into liquidation. So when companies went into liquidation, quite often at that stage there would be some sort of group employee arrangement. But now you're saying that that's more recognised and regularised.
It's defined. A lot of the law still depends on implementing regulations, which will set out the meat of the law. We haven't had those yet. So caveat is throughout the law is the implementing regulation. The implementing decrees will tell us how it's to come into play. Implementing regulations will tell us which industries may well be exempt from certain provisions. But under, I think it's Article 56, which deals with the collective dispute, it's recognised.
Okay.
How it will happen again is subject to these regulations, which will set out the actual formula and the practical way of doing it.
Yeah.
But, I wouldn't be surprised, and probably one of the first test cases may well be in the construction industry if there is a group action, because everybody's affected by the same kind of issue.
Yeah, and there's a lot of issues. Looking at overtime provisions and working hours, and I'm thinking also particularly with this is coming about along with the changes of the working week as well. One of the things that we're finding in construction is actually the traditional 6-day working week is still not quite settled as to which 6 days they are. We're seeing different companies doing different things at the moment. But how is any of this affected by the hours and overtime in the new law?
Well, dealing with it kind of in a two-pronged way. So firstly, the working week, I think everybody's still trying to get used to. I always think, today's the last day, and I remember, no, we work on a Friday. Yeah. And even though we're not mandated in the private sector to do that, I think the majority of people have followed that. And now, as I understand, certainly the space we work in, Monday to Friday is the default working week, with Saturdays and Sundays off. And obviously in the construction industry, you only need to give the 1 day off. And that can even be given off on, they could have worked on a Friday previously and that wasn't an issue. I think it's now up to employers to decide and determine which day off they want to give. The 6 days can be any of those 6 days, so that's not really affected it. It's more of a mindset to get your mindset around. We have a working week which is different. Yeah. In terms of overtime, there's been a change wherein the maximum amount of time a worker can work is 144 hours over a 3-week period. But the extra 2 hours per day for overtime still stands. Okay. So there's not a change there. And it's now prescribed under Article 19, the different kind of percentages that need to be applied depending on when a worker is asked to work overtime. So whether it's 25% plus basic wage or whether it's 50% plus basic wage if they're working irregular hours, 10 at night till 4 a.m. in the morning. And if they're asked to work on a day off, they get a payment in lieu or they get a day off in lieu. So it's all prescribed under Article 19 of the labour law, which makes it easier. And I think once employers decide which their working week is going to be, they can pick and choose which day off they're going to give to which employees.
Okay. And some of the typical examples of violations we've had in construction before, that this new law is going to specifically address those types of issues.
I think the new law's there to kind of assist both employer and employee. It's going to address violations insofar as remedies are provided, and they're the usual remedies of the fines, and it's set out at the back of the law of what will happen. But the violations in terms of pay, look, we already had a few years ago, as you're aware, ministerial decrees which dealt a lot with workers' rights, especially in construction, in terms of midday breaks, in terms of allowances, in terms of housing, etc. So a lot of those provisions have already been dealt with generally for the on-ground worker. The labour law as it stands now is there to kind of codify, define rights for all employees more, and also protect the employer. So it's a kind of balancing exercise. Okay. And I think, as I said, the introduction, for example, of redundancy and recognition is a huge step, because that's been a real issue in the construction industry. When payments haven't been made, payments can't be made, there's a knock-on effect, as you know. And then they're subject to lots and lots of employment claims, which then get stayed in the courts. So I think that's going to slowly become a thing of the past, because there's a recognition of, the buck stops here when there is unfortunately a closure of a business or otherwise. So, and also in terms of non-payment or in terms of the control of keeping passports or official documents, all of that's been outlawed now. It's specifically set out within the law.
I mean, I understand it was outlawed before, but it was common practice.
It was common practice, as we know, in the industry, but now it's specifically set out. And again, it's about modernising the approach and the mindset. And the level of fines, are they about the same as before, or are they? They're not dissimilar. They're not dissimilar. The levels of fine are set out at the back of the law. I've just got it in front of me just to ensure that I don't misquote the the provisions. The punishments and sanctions are set out Article 58, and depending on the actual wrong, the remedy is set out. So, for example, if I'm just looking at Article 60, for example, shall be punishable by a fine of not less than 50,000 dirham and no more than 2,000 dirham if an employer employs somebody without a work permit, or if they recruit an employee and leave them without work. So those are kind of fines you're looking at. And also if they close an establishment, i.e. they go into redundancy or otherwise, but they don't take necessary procedures insofar as they can to settle dues, they can also be fined. So again, it's just about having more clarity and transparency in terms of the remedies for the wrongs.
The provisions for discrimination are interesting because there is a perception that quite often people are discriminated against according to what passport they hold. And so I wonder how that's going to play out in the long term with employment.
Interestingly, in the law, discrimination is one of the first concepts that is touched. It's Article 4. I don't know whether that's deliberate because it shows the importance of it or just happened to go there. So we have the first kind of introduction to the law. We have the scope of the law, and it goes straight into discrimination. And that's Article 4. I think until we have a test case that goes to the courts to see how it's going to pan out, certainly what will happen now is we used to have to advise people who came to us with a potential good discrimination complaint to say, I'm sorry, you're just not protected. And it would often be good practice for employers, especially if they're international, to follow international best practice and do the right thing. Now they're mandated to do that because of the provisions under Article 4, equality and non-discrimination. And also there's a recognition of equal pay.
Right, okay,
May not be so relevant in the construction industry. But it'll be interesting to see how this actually pans out, because until we have that kind of test case, we don't know. With the passport discrimination, again, you're absolutely right. You can be doing the same job, and it's not only in the construction industry, but generally, and be paid a totally different wage depending on the colour of your passport. I think there'll be now challenge to that. I think people will be more willing to bring that challenge. So we're suddenly going to start having case law that's going to change the legal landscape of how we've understood the position to date.
And one of the other things which under the old laws, which was quite common, was the way people's packages were structured, and this sort of this allowances bundle that was put to one side, and then a core salary, which has there anything been changed in that in terms of
the law sets out that the housing allowance has to be given and must be provided. So it's okay to still have the split. The issue that used to arise, especially in the construction industries, people would change for a very, very small amount, and employers are always saying people will move around for the smallest amount. How can we lock them in? And we also used to have setups where 80% of the salary would be given as allowances, and we'd say that's not really okay, because even though there's no set guideline, at least 50% should be basic for obviously ESG purposes. I think now people revisit their policies and procedures, and they have to, because they have to introduce policies and procedures that we didn't have before. But for example, on harassment and records all need to be kept, and there's provisions to ensure records are kept, so employers have that duty. But I think now we're going to move towards at least 50% basic, and probably 50% of the housing and the transport. I'm not saying it will happen overnight, but remember the provisions all have to kick in. There's a year for everybody to get their act together. So even though the law kicks in in February next month, they have until the following year, February, to ensure they're fully compliant.
So the interesting period is going to be this year, commencing February, and then right the way through as people.
I mean, hopefully what we tried to say when the law came out, we did a number of back-to-back lectures we were asked to do. And we kept saying, be proactive, be proactive. But we also said that come the end of January, we know we're going to get many phone calls. Everyone's like, okay, the law's changing now from tomorrow. What do we do?
January this year or January next year?
January this year, they'll have people saying, what do we do now?
Yeah.
And I think that will happen.
Yeah.
I think it's, this wholesale change, it shouldn't be underestimated, and HR should be on top of what needs to be done.
Yeah.
Some have been very good and been very proactive and started the process, and some are still kind of finding their way around, and some will do it when they get a claim against them. They'll take the reactive approach.
Yeah.
But I think it'll all assimilate within the next few months.
I guess some of the big international companies are importing policies, and probably already have from other regions anyway.
Yeah,
so.
you always had the internationals who always wanted a kind of streamlined approach anyway to policies and procedures, and sometimes we had to say, no, they need to be more bespoke for this region, because not everything that's relevant from the US or UK is relevant here, and there's nuances in the labour law here. Yeah. For example, Ramadan leave and reduced hours that you don't find, or there's certain protections for indiscrimination that you can't give out here because, there'd be a contravention of the penal code. So I think the internationals will have, hopefully, I'm not saying they all will have, but they will have started to simulate the policies and certainly used their blueprint for what they have abroad. Yeah. But obviously this law applies across the board to everybody. So it'll be interesting to see those of them who have started and those who will end up spending a lot more time and money because they get their processes in order once they are unfortunately stung.
So the message really is that to start get your house in order
100%.
As quickly as possible. Will they start implementing the fines in this coming year, or
again, the implementing regulations will. It's interesting. Just before I came in here, I was having a chat with a colleague, and I'm like, we're going to new law, and we don't have implementing regulations as yet, which we don't. It will set out the transitional periods and what will happen.
Yeah.
I think because there's a year period within which everything needs to be in place. I'm not sure whether the actual fines will start being given now. They could be. I don't know. That's the answer. Until we have the implementing regulations, it's not clear. Okay. The message we send, and we sent it from 4 months back, was pretend the new law's in place already, act accordingly. Everything you do it in accordance with the new law, because the old law is out. So put people on fixed-term contracts. Act accordingly. Don't rely on the old law.
All right. Okay. Good advice. So, in terms of the gratuity, then I understand there's been some changes with the new law that's coming.
With the end of service gratuity, before, if employee was dismissed under the old Article 120, which was summary dismissal. Right. They forego end of service gratuity. It wasn't payable. Now it is payable, whatever the reason for dismissal is. It's a right that's accrued. Right. So that's an important change with the end of service gratuity. Again, subject to implementing regulations, which will set out more of the details.
Yeah. Okay. Well, thank you very much for being with us this morning, and thank you for giving us your times. Thank you very much.
Thank you, Michael. It was a pleasure, and thank you to INSITE as well.
And if anybody needs any further information, then Sarah's contact details will be available, so that she can follow up on any further questions you have. Thank you very much.
Thank you.